Our speaker today is Adam Kerwin. He is the founder of Kerwin Law Firm and the author of 2 books, The Asset Protection Guide for Florida Physicians and The Asset Protection Guide for Florida Residents. So whether you're a physician or a Florida resident, I think you have need to hear what he has to say today. Adam founded the Kerwin Law Firm with a focus on practicing exclusively on the process they call integrated wealth planning, which effectively combines estate planning, business planning, tax planning, and asset protection planning. With the litigious society that we have today, I think that is a great cause and great opportunity to hear everything that he has to say today as we do medical and business asset protection. Give a warm welcome for Adam.
All right. You want me up there?
Yeah, you go up there.
Okay. Good morning. As she mentioned, my name's Adam Kerwin, and I'm the founder of the Kerwin Law Firm. And we really focus our practice on 2 main areas, which are asset protection planning and estate planning, and end up working with a lot of physicians and business owners. And so today I'm going to be talking to you a little bit about asset protection. And before I delve into it, just a little bit of background on me. I ended up getting into the area of law really not out of a reverence for our legal system, but out of a feeling that it is pretty deeply flawed in many ways. And as a young kid, I had a younger brother. Some kids tried to steal a football jacket of his, and a fight ensued, and one of them ended up with a broken nose. And we're Irish, so we had fought a lot growing up. And so we figured, good, you know, you got your comeuppance. And well, it turns out that one of the kid with the broken nose, his dad was a lawyer. My family got sued, and the insurance company, which thankfully covered it, ended up paying roughly $80,000 to the kid with the broken nose. And I thought, you know, wow, as somebody who's had his nose broken a couple times, I never needed an $80,000 Band-Aid. So I thought, you know, this is clearly not a very just system. And so back then, in the days, LA Law was a popular TV show. So I thought I was going to go and, you know, right the wrongs of the world. And, you know, it became, you know, because we have a system that has devolved into, I think, of a legal system more than a justice system. And so being somebody that really loves justice and didn't like the inequities, I thought I would go and become a litigator. So I signed up for law school and quickly figured out that being a litigator was not the way I was going to change the world. So ended up becoming very interested in tax law, did very well in my tax law courses, and then later went on and got an LL.M, which is a master's degree. It's funny, you get your Juris Doctorate first, and then you go backwards and get a master's degree in law if you want to specialize in something. So I got my master's in taxation, and I met an attorney who was also a teacher at the LL.M program who focused on asset protection. And from the minute I started hearing what he had to say, I was hooked. I really thought it's an amazingly interesting area, and it really draws on, it incorporates aspects of estate planning and business planning, and so it's a really neat area that allows you that encompasses a wide you know, breadth of areas. But today I'm going to speak about primarily asset protection. I have about 45 minutes to speak, I'm told. So I'm going to try to, it's not going to be as, you know, super comprehensive. I'm going to try to hit on highlights. So at the end, when they have the question and answer period, please, you know, if you have anything as I'm speaking or a question that you've never gotten a good answer on, please, you know, let me know, and I'm going to do my absolute best to answer it for you. And if I can't, I'll give me your question, and I'll make sure I get you an answer. Asset protection is basically a way of using legal means. So a lot of times people think that asset protection is hiding assets or being sneaky, and it really isn't. Real asset protection planning is something that you do within the confines of the law If you ever end up with a judgment, you should be able to honestly, with your hand on the Bible in front of the court, and say, this is what my assets are, this is how they're held, this is exactly why I did what I did, and your assets should still be protected from the claims of creditors. That's what real asset protection planning is, and that's what we focus on. When you do asset protection planning, it's one of those things where the earlier you do it, if you do it before the bad thing happens, your options are significantly greater and the likelihood of success is also greater. It's kind of like if you're young and healthy and you want to go get a life insurance policy, you can probably get one that's cheap and that does what you want it to do. If you're an old person with a lot of disease, good luck getting a life insurance policy. That being said, a lot of people are under this false impression that if you have been sued already, that you're just SOL. There's not even any reason to try, and that's also wrong. Sometimes some of the reasons are because in the state of Florida, we have a lot of interesting exemptions. We have a lot of interesting ways to protect your assets that a lot of other states don't. Wage protection is one of them, and I'm going to touch on that. There's a way in certain circumstances that all of your earnings can be protected from the claims of creditors. And if you deposit them into something called a wage account, which is an account into which only your earnings are placed, that money is actually exempt from the claims of creditors. And once something is exempt, the law of fraudulent transfers, which is kind of the foundation on which asset protection is built, this is a law that basically says if I know you're going to sue me, and I take a bunch of money and give it away, give it to my spouse, give it to my brother, whoever it is, those can be unwound so that the creditor can reach those assets. But you have to transfer an asset, and one of the things that an asset for fraudulent transfer purposes does not include is an exempt asset. So if I have money in my wage account that's exempt from the claims of creditors, I can transfer that to a trust or to another asset protected vehicle. If I had assets in my individual name that were not protected, I could do things like spend those down. And so by the time the judgment actually hits, I'm more asset protected than I was at the beginning. So there are also things, which I'll touch on, where you can maybe dump money into a Florida homestead. This is another after-the-fact thing that you can do. So my point is that if you've been sued and you haven't pursued asset protection, your options won't be as broad, but it's still worth exploring what your options are, because you're not completely dead in the water. Let me just touch on the fraudulent transfer laws. Again, as I said, all asset protection planning is based on the law of fraudulent transfers, because that's where the lawsuit is going to happen. If you have been sued and you have assets in trust or in an insurance policy or a retirement plan or something like that, all of which are protected under Florida law, they're going to look at trying to pull those things out. And so what we're trying to do when we do asset protection planning is not only look at the vehicle. Most of the time when I get questions, people will say, is a trust protected, or is an LLC protected, or is a life insurance policy protected? They're focusing on the vehicle, and they're not at all focusing on the transfer. How did the money get into that vehicle? And you really need to look at both of those things if you're going to do thorough asset protection planning. And when we do this, we like to create a plan and that we can refer back to. And a lot of times people, I work with certain financial planners, and people will say, nah, I don't need to do financial planning, which I think is a real mistake. I mean, it's good to know where you're going financially. But more important from an asset protection standpoint, if you have a plan that says, I'm putting this much money away for these specific purposes, and my financial advisor has told me this is an intelligent thing to do, and later you're sued and they're asking, why are your assets structured the way they are? If you can pull this financial plan out and say, I did it for a reason. What you look for in a fraudulent transfer is typically, and this is the Reader's Digest version, but if you made a transfer with the intent to hinder, delay, or defraud a creditor, so what is your intent in transferring the asset? That's one way something can be a fraudulent transfer. And another is, did you make a transfer that rendered you insolvent, either unable to pay your debts and obligations as they come due, or from a balance sheet perspective, or your liabilities greater than your assets. So if we have these things broken down, we can make sure that we're not making fraudulent transfers. I know some of the other people that have talked before me talked about things like valuation, talked about doing intelligent financial planning. These are all pieces of the puzzle which come together and will make your asset protection plan a lot stronger. So I'm a big advocate of the team players. People also will have they put people in little boxes. So you have your accountant over here that does my taxes, my attorney over here that does this, my financial advisor. It's a great idea to have everybody talking to each other, because what can be an excellent idea from a tax planning standpoint can be an awful idea from an asset protection standpoint, vice versa. So we really do want to try to integrate all these things together. So, but when we're doing this, the goal is that we're creating this plan, which includes your assets, are you solvent, what are your intents with the financial plan. We're trying to create the defense to the fraudulent transfer lawsuit that we hope never comes. So if everything has been done, the vehicles will be protected, the transfers into them will be defendable, we'll have done it for all the right reasons, and that's real asset protection planning. So it's a little bit more involved, but if you do it, it works a hell of a lot better than trying to piecemeal it on your own or say, well, everything's owned by tenants by the Entireties, so I'm protected. So that's kind of a quick background on the reasons to do it and some of the things to think about, not just vehicles, but also transfers. So speaking of vehicles, let me go through a few of these today. I won't be able to do all of them, but there's three basic broad areas of ways to protect assets. The first one is state law exemptions. And like I mentioned before, we have a lot of them in the state of Florida. We have an unlimited homestead exemption, meaning that if your house meets certain requirements, it'll be protected from creditors' claims. We have a form of joint ownership between spouses, which is called Tenants by the Entireties. Life insurance, the cash value on life insurance policies are protected from creditors' claims. Same thing with the annuities. 529 plans, so college savings plans. Florida prepaid program. These are all examples of things that if you have money in these vehicles and the money got into those vehicles in a way that isn't a fraudulent transfer, those things are protected. So state law exemptions is your first broad topic. The second is domestic entities, and by this I mean things like trusts. A lot of people, and we have like revocable trusts and irrevocable trusts. A lot of people think irrevocable trusts are pretty scary, and we'll explain that not really. I also have written some articles on this, so if you wanted to go back and see what I said or get an overview, there's something called the Flexible Irrevocable Trust. It's an article on my website. You can feel free to download that, and that'll explain why trusts are protected or not. And then there's also legal entities like limited liability companies, or a lot of physicians have PAs, professional associations, that they run your practice out of. I have another article on my website that's called Why the PA is the Worst Legal Entity to Own Your Medical Practice, which a lot of people find surprising. But if you're interested in that topic, which I probably won't be able to fully touch on today, something else that people in the medical profession may be interested in learning about. The third and broad category is foreign or offshore planning. I'm really not going to touch on that today. It can, in certain circumstances, be a legitimate way of protecting assets, and I certainly have done it, and I still do it, from time to time. It's a little bit more difficult now because of some regulations that were passed during the Obama administration. Foreign banks do not like dealing with U.S. citizens anymore. So you have to actually have a significant amount of assets to open up an offshore account. And if you're using a foreign trust to try to protect domestic assets, it can actually work worse than using a domestic approach. So I think that you should have a domestic piece of your asset protection plan to protect domestic assets and a foreign piece, because if you're found to have, after the bad thing happened, participating in assets leaving the confines of the United States, there's a potential to get thrown in jail, which is kind of a big downside. So I don't want anybody. There was an interesting case, a guy named Stephen J. Lawrence, one of the famous offshore trust cases, and he ended up in a Miami jail for about 6 years, so a pretty significant period of time. And at one point in time had a roommate named Queenie, which also sounds like a big downside in my book. So again, I'm really not going to touch on offshore. If offshore is something that is interesting to you, there's a portion of my book I talk about it, and if you wanted to ask questions afterwards, again, I'm happy to help answer those questions. Let me start by going back to the state law exemptions. One of the big ones is the Florida homestead, and here in Florida, your primary residence is protected from the claims of creditors if it meets basically a 3-part test. The first one is the acreage requirement, which a lot of people are not aware of. And the acreage requirement says that your primary residence has to be, if it's located in the city limits, so the incorporated municipality of Orlando, for example, it's protected up to 1/2 acre. And if it is in the unincorporated county area, then it's protected up to 160 acres, so significantly more. Another difference is that if you're in the unincorporated county and you have a business type structure on your property, it is also protected. So even if you lived within the city, you're within the 1/2 acre, you have a grandparents' suite or something that you're renting out to somebody, that rental activity is probably not going to be protected. Whereas if you're in the unincorporated county area, it would be. And the reason for the 160 acres, I think it was back in like 1867 or something when it came into the Constitution, the size of an average family farm was a 1/4 section, and that's why they allowed, because they figured city slickers only need a 1/2 acre, whereas people that live out there are probably doing ranching, farming, groves, or something like that. They're living off their land. So if you're in the city, for example, and you have a homestead on 2 acres, for example, so we've exceeded the 1/2 acre, lot size, there's 2 things that can potentially happen. If you are lucky enough to have your home located neatly on 1/2 acre, and the other 1.5 acres you could lop off and give to the creditor, and it is usable by the creditor, which is an important part, then you have that option. So there was an interesting case where a guy was sued. He was saying his homestead exceeded it, so he said, I'll tell you what, I'm going to cut a donut hole out of the middle of my property. That's what you can have, Mr. Creditor. By the way, I'm not going to give you ingress or egress over my land to get to it, so ha ha ha. And the court said, no, this is unusable by the creditor, therefore you have to move to option 2. And option 2 is, if you don't have the ability to partition off or lop off the excess, is that they will force a sale of your home, and then whatever portion of it is represented by the 1/2 acre is what you get to keep. And at that point, you're no longer allowed to say, well, okay, the total property is $1 million, but my house sits on this 1/2 acre. That's my part. At that point, if the property's sold, the property's sold. So if it's $1 million, is the net sales proceeds. Since a 1/2 acre represents 25% of the total 2 acre parcel, you get to keep $250,000 and your creditor gets the balance. So understanding, if you have something in excess of the 1/2 acre, there are some things that you can potentially do to protect it that are a little bit beyond the scope of this. So, but just understand that these are the acreage limitations. So if you are going and moving to, looking for a new house, be aware of this, especially if you're a physician, business owner, or somebody that doesn't want to lose their house to a creditor. Another interesting thing is what is protected, or I guess I should touch on the other requirements. Another one is that it has to be owned by a natural person. So that's a requirement of the Constitution. And so a lot of people have been told to put their house in a revocable trust in order to prevent probate, which makes good sense. There was one case, it was called the Bassonetto case, where a woman took her home, put it into a revocable trust. The bankruptcy trustee made the argument that the trust is not a natural person, And the long and short of it is that Mrs. Bassanetto lost her homestead exemption. Now, there's been a series of other cases out there that have gone the other direction. So the final answer has not been determined by the Florida Supreme Court, so we don't have a 100% clear answer. I think that the better analysis is that it should not be, held against you, and it should be treated as still being owned by a natural person. But if why risk it? So what I typically will have people do is have the home owned by you. So if it's a husband and wife, husband and wife own the property. You can do a special kind of deed called a Ladybird Deed, which means that if you decide to sell the property, you get to keep all the sales proceeds. It's your home. But on the death of the last of you to go, it can then be added to your trust. So it avoids any kind of judicial process, similar to probate. And so you get the benefit of avoiding probate and still having the property titled in your individual name. The third requirement is you have to be a resident of the state of Florida, which for most people is, not really a big deal or a question. However, the cases where this comes up tend to be more with people that are here on a visa. So there was a case where a gentleman was here for a number of years, actually, on a visa. No signs that he was going to get turned down for any extensions. But they said that since you do not have the right to permanently reside in this country, let alone the state of Florida, that you're not a permanent resident of the state of Florida and therefore no homestead exemption. Two other things. Also, what is protected? The land is protected. The building, the structure is protected. And fixtures are protected. But not anything else. So the Renoir that hangs over your solid gold mantelpiece is not protected. However, the solid gold mantelpiece itself, since it's bolted to the wall, is protected. Theoretically, I don't know if I would push it, but theoretically, you could install solid gold commodes in your house, and since they're bolted to the floor, that'd be a way to ameliorate the value of your home, and but I say that kind of tongue-in-cheek because I don't know if I'd push it. But just understand that contents is not. So if you do have valuable things like antiques or art or things like that, you need to consider them a separate asset that actually needs to be addressed when doing planning. Last thing I'm just going to talk on is there was an interesting case called Havoc O V Hill. And this was a case where a gentleman named Delmer Hill, I believe he lived in Kentucky. He was in the middle of a lawsuit. And he decided that determined that he was probably not going to fare real well. So he sold everything he had, moved to Destin, Florida, ended up buying himself a nice home, and moved in 3 days before a $15 million judgment was handed down against him. And so the creditor came down and he said, well, I'm a Floridian, this is my homestead, too bad for you. It's fully protected. And they argued that this is your typical fraudulent transfer. You did this with the intent to keep money away from us, the creditors, and the court inquired, and Mr. Hill ended up admitting, yes, I did it with the intent to hinder, delay, and defraud my creditors, which is the single worst thing you can say in a fraudulent transfer lawsuit, by the way. And so he said, but I should still get to keep my house. And the theory is that the Florida Constitution gives me my homestead protection, whereas the fraudulent transfer laws are merely statutory or created by the legislature. And the legislature basically does not have the right to take away a constitutional right by enacting a statute. And it went to the Florida Supreme Court, and they agreed with Mr. Hill and got to keep his house. So these are some of the, this leaves open some after-the-fact planning options. If you've already been named in a lawsuit, for example, Mr. O.J. Simpson, that's one of the reasons he moved down here. It wasn't just for the golf. But if you knew that you were being sued, or you're already in a lawsuit, or all the way up until the date of the judgment becomes final against you, if you did things like pay down a mortgage on your home, or ameliorated the value somehow, added a swimming pool, put in expensive fixtures, things like this, or just bought a big house and get rid of your old one, buy an even bigger, more expensive house, as long as it meets those requirements. They can't set it aside as a fraudulent transfer. The only glitch in that is that filing for bankruptcy would not be an option for a period of 10 years because of changes to the bankruptcy law back in 2005. They now say if you fraudulently transfer money into your homestead and you file for bankruptcy within a 10-year period of time, that transfer can be unwound. So if you did decide to dump money into your homestead, just understand you're waiving you're basically no longer able to file for bankruptcy for a period of 10 years. I know I'm probably getting close to losing time, and I've got a lot more to talk about. Let me just talk briefly about some of the others. We have, for example, pension plans. In the state of Florida, things like 401k plans, profit-sharing plans, defined contribution plans, defined benefit plans, all of which are great ways to get not only a tax deduction and save for retirement, but it's also a great way to protect those assets from the claims of creditors. They're all protected. Also, things like IRAs. So IRAs, whether it's a Roth IRA, a simple IRA, a traditional IRA, you name the IRA, it's protected. IRAs, though, are protected under state law. So if you're planning on living in Florida for the rest of your life and you have money in IRAs, you know, bravo, you have a protected asset. If you know that you're going to move to another state, potentially, say, California, which I know does not have protection for IRAs, then you want to rethink things like, a lot of times the financial advisor, you're living here in Florida, they'll say, hey, you have a bunch of money in a 401k plan, why don't you roll it to an IRA? Again, if you're going to stay in Florida, not a bad idea. There's various reasons for doing that. But if you know that you're going to ultimately end up in California or a state where IRAs are not fully protected, you've probably shot yourself in the foot. So again, just understand the nuances of what you're doing. But in general, retirement plans are protected from the claims of creditors. We also have something called tenants by the entireties, and this is a form of joint ownership between a husband and a wife. And so if me and somebody in this audience, for example, decided to go and open a joint bank account, we're obviously not married, and we want, for some odd reason, if I die, you get it, and vice versa. The best we can do is what's called joint tenants with rights of survivorship. And in that, the law says I own half the account, you own half the account, and therefore if I'm sued, my creditor can reach my half of the account. Same with you. Now with a husband and wife, if they end up purchasing property together and it's tenants by the entireties, then each spouse is deemed to own the entire thing. So it's an ancient concept that was started, I think, in like the 1600s back in England before women were actually considered chattel at that time. So they weren't allowed to own anything. And this was a form of ownership that came into existence that allowed women to sort of own women as long as a man was involved. So interesting history. But the way it works in modern times, thankfully women are no longer chattel, is that if you are sued and it's a lawsuit only against, say, husband, for example, then since wife owns the entire property, it's exempt from the claims of husband's individual creditors. Likewise, if wife is sued, because husband at the same time owns the entire piece of property, it's also exempt from the claims of wife's individual creditors. Now, as I mentioned before, everything has an upside and a downside. So the downsides with tenants by the entireties property is people will say, I love tenants by the entireties. They go and put all their rental homes as TBE and their bank accounts as tenants by the entireties. And they end up, then somebody slips and falls on one of their properties or a renter sues them. They get a judgment against the property owner, which is husband and wife. If you get a joint judgment against husband and wife, then they can walk through all the rest of your tenants by the entireties property. Or if husband took out a loan guaranteed by wife or vice versa, again, they get both of them on the hook. Tenants by the entireties doesn't work well for you. The other downside is that it's severed upon the termination of the marriage, which could be, say, by death. So if you, are a doctor and you just get named in a lawsuit and then you learn, and then all of a sudden your spouse, passes on, you have, two things to be sad about. You just not only lost your spouse, but you also lost all your asset protection at the same time. So tenants by the entireties is something that is good to, if you have a wage account, your checking account, things like that. These are all excellent reasons to use it. I probably wouldn't say use it as your primary means of protecting assets, but it does have its place. Cash value and life insurance and annuities is another. So whether or not these vehicles make sense is really, varies. A lot of times people think that investing in life insurance is that's the best thing since sliced bread. It's the solution to every problem. That's obviously, not true. Also, there are other people that demonize it and say it's the worst thing you can ever do. Never invest in life insurance, and that's not the right answer either. It's a tool like any other. So again, another reason to have a team of people around you is that oftentimes what makes the insurance product good or bad is how it's structured. So there are situations where it can be actually an excellent investment vehicle, and it can also provide asset protection benefits. If you have the professional that's good and will structure the policy in a way that maybe he or she gets paid a little less, makes the policy work a lot more. If you have somebody who's interested in maximizing their commission on the sale of the product, it probably won't work as well. But it does have certain benefits from an asset protection standpoint. And the final thing I'll talk about is the wage protection under the state law exemptions, and there are others. So if you have questions, let me know. But the wage protection is interesting. If you are head of family, which means, under the definition in the statute, if you are provide more than 50% of the support of a dependent, so that dependent could be a spouse, a child, your grandma, your ex-spouse, and even somebody that you're not related to if you're legitimately paying more than 50% of their support. But if you are that person, then 100% of your income, and by this I mean of your earnings, actually, it's of your W-2 income, meaning not business profits or corporate distributions, things of that nature, but your W-2 income, 100% of that can be protected from creditors' claims. And if you then take that money and you put it into a bank account that is not commingled with any other assets, it's typically called a wage account. I will tell you, if you go to the bank and you say, I'm interested in setting up a wage account, they will probably give you a blank stare and have no idea what you're talking about. So, and just real quickly on banks not being oftentimes helpful, if you go to set up a Tenants by the Entireties account, sometimes they'll give you a little choice. Sometimes they won't. There's you have to look at how the application that you set up the account is. Sometimes it's the default, sometimes it is not. And then certain banks like Wells Fargo have just said, we're not going to allow you to set it up. So if it's important, make sure, Wells Fargo wouldn't be the place to go. But just, I have an article again on my website, or you can email me if you'd like, and it gives you instructions on how to tell exactly how to set up a Tenants by the Entireties account, and also how to check to see whether the account that you have right then happens to be Tenants by the Entireties. But getting back to the wage account, if you deposit your earnings into a wage account, then something that's not commingled with other assets, then that's 100% exempt from creditors for a period of 6 months, which, as I mentioned earlier, gives you the option to say take it from the account, transfer it into, say, a trust, and now your earnings, even if you're in the middle of a lawsuit, 100% of the funding of this trust is done with exempt assets. So you have a pretty rock solid defense to any claims of things being a fraudulent transfer. So a very important thing in the state of Florida that we have, and if you do have things like K1 income and things like that, then what you want to do is make sure that those are paid to the owner of the stock or LLC membership interest. So we want to make sure that those are moved into, say, your trust, for example. So now those dividends or distributions are being paid directly into the trust or protected vehicle. Your earnings are protected from the claims of creditors, and everything works out rather nicely. With the couple exceptions, again, if you're not head of family, so sometimes people will come and they'll say, I do not have children, I do not have a spouse, or if I do have a spouse, they make roughly the same as I do, so I'm not really have no dependent. Unfortunately, your income is not 100% protected in that case. Another big downside is that individual physicians that have their own practices. So if you are Dr. Jones, you know, and you own Dr. Jones PA that you own 100% of, because you have a controlling interest over the company that employs you, you do not get the benefit of the wage protection. So if you're in that situation, there are some things that you can potentially do to try to get around it and to at least minimize the damage and give you some good arguments. That's the other thing too. If we can structure it so it's a more complicated issue of it's maybe not black and white. There's no rock solid way of doing it, but we give all sorts of good arguments. That means suing you to get past it is going to be more expensive, and your ability to negotiate a better settlement is increased. So these are some examples of the state law exemptions. Let me touch quickly on trusts and LLCs, and then I'll turn the floor over to whoever, and I'll answer questions. With trusts, there are basically three players in a trust. There's the settlor of a trust, and that's the person that creates and funds the trust. There's a trustee or multiple trustees, and they have control over the assets once they're in the trust. And then there are the beneficiaries, and the beneficiaries are the people entitled to receive assets or benefits from the trust. A revocable trust does absolutely nothing to protect assets. So if you have a revocable trust that you did for estate planning purposes, I've had a lot of people who are under the misconception that those actually provide some kind of asset protection. Unfortunately, they do not. So if you have your revocable trust and you get sued, do not think that you're safe, because you really aren't. If it is an irrevocable trust, then the rule is that if you're the settlor, you're the person who puts money into the trust, and you're also a beneficiary of the trust, so this is called a self-settled trust, then a creditor can reach the maximum amount that could be distributed to you. So let's say I take $1 million, I throw it into a trust. The trust agreement says that I'm the settlor, because I'm the one putting money into the trust. I also am the beneficiary. The trust agreement says Adam is the beneficiary, and the trustee can give him as much or as little as he sees fit, his sole and absolute discretion. If I do this and later end up with a judgment against me, and they come back and they say, the creditor comes and wants to get the assets in the trust, and you, the trustees, are great trustees, and you say, we are going to exercise our discretion and distribute absolutely nothing to Adam, haha, go pound sand. Unfortunately, since you have the option, you have the right to give me the entire $1 million back. Remember, it's the maximum amount that could be given to me. The creditor could still reach the entire $1 million. Likewise, if the trust agreement said that I was entitled to receive up to $50,000 a year, they get their judgment, they can go and ding the trust for $50,000, come back every January 1st, ding it again for another 50 grand until the judgment is paid or the trust runs out of money, whichever comes first. So there are some interesting things that you can do with trusts. So if you have and when we talk about revocable versus irrevocable, again, I did say I have that article to look at, but it really comes down to, what is the goal of the trust? When you go into Google and you say irrevocable trust and you want to read about it, every single article, this is why I actually wrote this article, is referring to a special kind of irrevocable trust that's designed to keep life insurance proceeds out of your estate. So it's true that if you are trying to remove assets out of your taxable estate for estate tax purposes, then there are a lot of restrictions. You can't change the trust, you can't serve as trustee, and there's some other things that where you're restricted. If, on the other hand, we really don't care whether the assets remain in our taxable estate, each person is allowed to leave almost $5.5 million to the next generation now. So a husband and wife can leave almost $11 million to the next generation. Oftentimes, we're dealing with people that don't have net worths of $11 million. So if things are still in their estate, they're really interested in asset protection, who cares? It also makes it easier when you put assets in, you don't have to go get them valued every time. So there are some good reasons to still use it. But if we have one of these things, you can put assets into the trust. You can still retain a right to change where things go when you pass on. There's even ways to potentially get the assets back out. So if, let's say, originally, husband creates the trust for the benefit of wife and children. If you want to get assets out, you can potentially make distributions to the spouse and children. You can still control the money. Husband and wife can do that jointly. And but if wife, God forbid, passes on, there are still ways to get the assets back out, or you can also move these trusts to a jurisdiction that does allow for self-settled trusts. It usually involves naming a trustee in that jurisdiction, like Delaware is one, Tennessee is one, Nevada is another. So there are a lot of ways that these can be really, really flexible and provide you with really good asset protection. So it's really just sitting down and meeting with people and understanding exactly what their needs are. But these can be very, very flexible and not terribly expensive. One other thing I just want to touch on real quickly is leaving assets to children. Oftentimes, when I read asset protection or estate planning documents, it'll say, when I die, I leave assets to my children, a third at age 25, third at age 30, third at age 35, some version of this. First of all, and it will be outright distributions, because parents are like, well, my son's a doctor, or my daughter's an engineer. They're responsible people. We can just give them the money. We don't need to put it in trust and make things difficult for them. Unfortunately, I've had clients that their parents die while they're in the middle of a lawsuit, and that money that they inherit is completely unprotected. They can come in and take it. What you can do instead is leave it to a trust that is for the benefit of your children. They can, if you feel there's no need to protect them against, from themselves, you can name them as the trustee, because remember, you're the settlor, they're the trustee, they're the beneficiary. It still provides them with asset protection. They can control the assets, they can use the assets, but they're 100% protected from creditors' claims, and this can even be divorcing spouses, which, let's face it, is a pretty big class of creditor. Just a quick aside, two creditors that some of this stuff will not work against, I call them super creditors, are the IRS and your spouse. So don't think that this stuff is going to help with either of those situations. The other thing just to think about when you're giving your kids, what we're really doing when we're doing planning is we're trying, especially when our children are involved, the most important thing we give our kids are not iPhones and the gadgets and the money. It's the unconditional love. It's the support. It's the kick in the rear end when they need it. So if you wouldn't do something while you were living, why on earth would you do a trust document that does something when you're dead? So if a child of yours came to you at age 25 and said, "Mom, can I have $1 million?" The answer is probably going to be highly dependent on who they are. If it's your daughter and she's a hard worker, did great in school, wanted the money to start a business, wonderful. You'd probably jump through hoops to get her the money. If she is a spendthrift and sits in the basement all day watching cartoons and goofing off, then no, you're probably not going to give her 25 cents, let alone $1 million. Not because you don't love her, but because you do love her. The money is going to get wasted and she could hurt herself. So you can actually create trusts that provide incentives. So things like matching income, rewarding people for doing well in school, a whole bunch of these things. And if you're interested in it, I can, I've also have a memo on that. I have a lot of memos. You can go and download it on my website. It's like called your #1 asset. Another thing to supplement these types of things is letters to your children. You can write a letter to your child that says, I think everybody should have at least one letter that says, I love you, I'm proud of you, I know you can go do great things. I have a lot of letters to my written that say, why I don't trust the government and, a whole bunch of other things. But this way you can go and have a, continue to be active in your child's emotional, upbringing and, building them as people, but having letters that say, when they go into high school, when they go into college, when they get married, this way you can be a part of your children's life. So if you have, and you can write letters to the guardians, people that would be raising them too. So if you have well-educated guardians, well-educated trustees, you have a trust that rewards them for the same things that you do, and you continue to have letters to build their emotional support, and they end up getting their assets in a trust that will be protected from the claims of their creditors, that's a pretty good estate plan. So, and very, very few people do that. So just something to think about. The final thing I'll just talk about is LLCs. The way that an LLC works to protect assets basically is that if you have a corporation, for example, so an Inc., and me and somebody else, let's say I own 50% and you own the other 50%, I end up getting sued, my creditor can come in and just take my 50%. And now you, my partner, are in business with my creditor, and usually nobody's happy at all. I call that outside liability because it has nothing really to do with the asset. Let's say that our business owns a restaurant or something. So we have ovens and assets and money in the bank and all that. If I get sued in an automobile accident, so I'm not being sued with respect to our business at all, I'm just in an automobile accident or I default on a loan, I got somebody suing me from the outside, that's the liability that I'm concerned about. If it's an LLC, the same situation. We're 50-50 owners. I come in, get sued. If I have an LLC, they can't take my interest in the LLC. They can get what's called a charging order or a lien against it. So they can't take the interest in the LLC. They can't reach any of the assets inside of the LLC. They can't vote the LLC. So all those things are, sound wonderful. But because of this lien, I've seen people that say, oh, LLC or family limited partnership is wonderful. Husband owns 50%, wife owns 50%. They're nearing retirement age. If husband or wife ends up with a large judgment against them, just understand that since any distribution made from that entity has to be made, the part that would have gone to me has to go to my creditor, just understand that it's really not that great of an asset protection tool unless you think about losing up to 50% of every asset in that trust if you're going to live on it. If it's in an LLC and you're young and you can just say I'm not going to make a distribution for the next 20 years, perfect. You have a pretty good plan. But if you need to access that money, and you'll see things people say, well, just sell a pencil to the LLC for $100,000, or pay yourself a management fee, or things like that. In the real world, judges don't put up with that. You have to show a sound business reason for doing what you're doing, or the operating agreement says we can make disproportionate distributions, so let's just make them all to the person who doesn't have the judgment. That doesn't work. So just be aware of that. The other type of liability, which is inside liability, so I have a piece of rental property, for example, somebody slips and falls. That way, corporations and LLCs are basically the same. If you are the owner of the corporation or LLC, somebody slips and falls on the property, they can, or slips and falls in the business or sues you because your pizza was horrible or had a rock in it or something, then they sue the business, the entity. They can get a judgment against the LLC. They can reach the assets of the LLC, but they can't sue you individually. And so from an inside liability standpoint, the corporation or entity getting sued, LLCs and corporations are pretty easy or pretty similar. From a outside liability standpoint, they're very, very different. But there's I can't really think of any good reasons to use an actual corporation anymore. If you have a corporation, a PA is a form of a corporation, which is one of the reasons I say it's not a good entity to own your medical practice, then I would really consider switching to an LLC because it can be taxed as a corporation. If you say I want it to be taxed as an S corporation or a C corporation, you can have an LLC that's taxed in those ways, but you still get that extra charging order lien protection. But also, just don't be under the false impression that the charging order is this holy grail, which so many people have claimed it is, because it really isn't. I know I went over my time, and I'm sorry about that.
That's okay. Lots of great information, lots of great stories.
Okay.
I know we probably have a lot of questions in the audience. I saw Connie first, and I'll get to you guys up here front.
Thank you. Great presentation. I have two real quick questions.
Okay.
One is, it's my understanding that on Tenants of the Entirety, if Mr. Jones marries Mrs. Jones and then adds Mrs. Jones to his checking account, the assets that were in there before the addition is made are still attachable. Is that correct?
That's right. The Tenants by the Entireties has something, there's these things called unities, and one of the things they look at is that the Tenants by the Entireties interest in husband and wife has to be created at the same time. So and that's
a
one
new
of the
checking account would be
right. So if Mr. Jones has an existing checking account, he should close that account. Him and his wife should go open up a brand new Tenants by the Entireties account, and then put money into it. That would be protected, but you're right. Just adding a name does not, I mean, it's a...
And real quick, the second thing is I just am a big proponent of umbrella policies. Do you see that as a strong leg of the asset protection?
Yeah, I'm a huge proponent of umbrella policies. I mean, as a first line of defense, umbrella policies are typically not terribly expensive, and having the ability to have anywhere from $1 million to $3 million, I personally think 2 is a great amount for the average person. But you know, having a good umbrella policy can save you such a headache. Because even if we have an asset protection structure, you still have to defend it. And if you have an insurance policy that will come in and pay for a lot of the attorney's fees, because let's face it, attorneys are not at all cheap, and also gives you the ability to negotiate settlements. So long and short of it, as huge proponent of umbrella insurance, I think, or umbrella policies, great idea as a first line of defense.
Mitchell Gordon, I'm an insurance broker, and contrary to Dave Ramsey and Clark Howard, I truly believe annuities are one of the safest things you can get in the state of Florida.
Okay.
Not variables, the other ones.
Okay.
And I have, they avoid probate, and if you get sued, they can't touch it.
Correct.
But I did find an obscure thing on an attorney's website that I've never actually been able to ask anybody, that I've never found an attorney or an agent that knew, that if you take money out of the annuity, put the cash in your account, and as long as you can prove that cash came from the annuity, a lawsuit cannot touch that cash either. Is that true?
That is correct.
Okay.
And I can get you I can't remember off the top of my head, it's in the book.
I have the statute. I carry the statute with me.
Oh, okay.
But I just wanted to make sure from a professional that I was always thinking correctly when I tell everybody
No,
that.
absolutely. It's because the language of the statute says proceeds of an annuity are what's protected. So as long as they're not commingled with any other assets, then yes, if you pull money out of an annuity, put it into an account that's not commingled with any other assets.
Okay, commingled. I didn't know that. Thank you.
Right. Don't commingle it. So don't just throw it into your checking account with everything else that you're tossing in there. But if you set up a separate annuity proceeds account at wherever your bank or brokerage house is, so you can clearly trace them, it's being able to trace them that's important. So if you document your file correctly, or you document your thing, so only those annuity payments go into it, that is actually protected from the claims of creditors, even though now it's invested in the case it was CDs.
I'm great. I'm glad I asked, because they're so misunderstood, and people, to me, no one has ever lost $1 in an annuity in the state of Florida ever. So they've got to be one of the safest things to do.
Yeah, and it really, I mean, like I said before, I think annuities and insurance policies can play, I mean, if they're properly structured and used in the right way, they can be an amazing, tool. They are exactly that. Are they good in 100% of the times, especially things variable annuities? No, they can be used for good. They can be used for or structured in a not so good way. But definitely a tool. Definitely, I think, an excellent tool to use as part of an asset protection plan. Also, the stream of annuity payments that come off of that. If you now have a pot of money that's exempt that can be invested in not just how it's supposed to be invested in, say, a financial product, but you can invest it in, there's an argument that it shouldn't be invested in, say, real estate, because you really can't own that inside of an annuity or financial product. But if it is invested in you could have a managed stock portfolio, so you have some flexibility there. Also, if after the fact you needed to have a pot of exempt assets, remember, which are not assets from a fraudulent transfer standpoint, to fund a trust, which could then maybe use those monies to turn around and buy an interest in an LLC. By the way, a single member LLC does not protect assets from creditors. That was probably a big thing I should have mentioned. We had a case here in Florida. But let's say you have a single member LLC. Now you're in the middle of a lawsuit. You can't transfer your interest without it being a fraudulent transfer. Maybe you take your annuity proceeds account, you transfer them into a trust. Now that's not a fraudulent transfer. Now the trust purchases for full value a 25% interest, say, in the LLC. Now we've taken a non-exempt asset, single member LLC, or a non-exempt asset, a single member LLC, and we've added at least charging order protection to it because we had a pot of exempt assets that we could transfer away and then you'd be used to purchase an interest in it. So there's all sorts of interesting things that you can do. I couldn't talk about some of it. The nuances, the devil's always in the details, but so is God. So it's always, I'm sorry, go ahead.
Hi, Adam. Janelle Padula, Longwood CPA. So we spoke about multi-member LLCs, and from a tax standpoint, that either triggers a partnership return or an S corporation return in the case.
Right.
So if we know that W-2 wages are protected, are guaranteed payments to partners protected in a partnership?
It's a little bit of a gray area. Her question was, are guaranteed payments which are payments to partners under a partnership agreement protected as well? And it's a little bit of a gray area, but I think that the much stronger answer is yes, because it doesn't, it says earnings. Earnings in exchange for services is really what the statute requires. And that is what a guaranteed payment is. It's, so I think the much, much stronger argument is that it is, even though it may not be technically a your classic W-2. But yes, there's a teeny bit of gray in there.
We'll take one more question.
What about the idea that in the LLC, I get a judgment against the LLC and they say, hey, we'll just pass down expenses instead of actual income. You're a 50% owner, now you got to pay part of the property taxes, part of the insurance bill.
Right. They call that the KO with the K1. The way that it works is if me and you were in a partnership together and it earns, let's say, $100,000, we each get a K1, which means that I have to pay my 50% tax on 50% of that money, and so do you, even though no distributions were made from the entity. There was a case called Evans v. Commissioner, and another one, it was Revenue Ruling 77-137. And both of these cases, which is what this KO with the K1, I call it an urban legend, if you will. In those cases, what happened was somebody took their partnership interest and they transferred it to somebody else. So there was an actual transfer of the underlying partnership interest. When that happens under state law, the person that ends up with the interest does not get the right to vote. They have something called the rights of an assignee. So they can't vote in the partnership unless the other members or partners vote them in. Now, if you've physically given me your partnership interest, or if we're in partners, I give it to you, for example, it makes sense that you should get the K1. You own the stock, you own the partnership interest, or whatever it is. When somebody gets a charging order against you, so let's say I didn't transfer my interest to you, but you got a judgment against me. The language of the statute says that you have the rights of an assignee, but you don't own the actual asset itself. So the short answer is that no, I do not believe that giving the K1 to a creditor will probably work. And also there's a lot of downside to it because both Evans v. Commissioner and the 77-137, both of those involved an actual transfer of the underlying asset, not just somebody had rights. I mean, if I have a lien against your rental property, do I have to pay tax on the rental income? I really don't. There's a lot of flaws in the argument. And let's say I did it anyway. So, you have the judgment. I start sending you the K1. Well, if you say, to hell with you, Adam, I'm not putting it on this, you fight it. It ends up, if I'm not reporting it, because I think you are, it could end up with penalties and interest, and it could really come in, and now you have a problem with the IRS. And that's, not somebody you want to have a problem with. So the answer is no. The KO with the K1 I do not think works. I actually have something written on that in my book. So if you're interested in MOROF members, I think we have setting it up so that you can download it for free if you want. So won't even cost you anything.
Thank you so much, Adam. Let's give him a round.
All right. Thank you very much. I appreciate it.